Good afternoon again, Your Honor. Joe Simon on behalf of Mr. Treadway. What's your name, Jacob?
Jacob Treadway. Thank you.
Your Honor, we're here for sentencing. We have no comments on the recommendation other than to say my client can pay his anticipated fines and costs today. And he's going to fulfill all the requirements the court gives.
Sir, anything you want to say?
I'm sorry for the mistake I made, Your Honor, and I'll learn my lesson. I'm never going to drink and drive again. I promise.
Court does acknowledge this is not a serious misdemeanor as defined by statute. However, does believe there are reasonable grounds to depart from the presumption of a non-probationary sentence. The alcohol screening and assessment identifies the benefit of outpatient programming, weekly attendance of AA meetings, and abstinence from all intoxicants. Therefore, the court will follow the recommendation of probation with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. Therefore, the sentence of the court place you on 12 months probation. You're to pay $855 fines and court cost, $100 prosecution recovery cost, $100 police agency recovery cost, $360 probation oversight fees. You can pay those today.
Yes, Your Honor.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete outpatient treatment, at Dawn Farms, including all recommended aftercare with status reports to probation. You're to attend one AA meeting per week with proof of probation. You're to provide proof of the victim's impact panel attendance to probation. I'll continue the sober link testing for an additional 30 days in lieu of 4 days in jail. I'll order 93 days in jail. Credit 1, balance suspended. Thank you.
Thank
Your Honor.
you.
Court calls the case of the people versus Kevin Smith.
Public Defender Natalie Pate with on behalf of Mr. Smith, who's approaching. Please state your name for the record, sir.
Kevin Smith.
Thank you, Your Honor. I have had the opportunity to review the sentencing recommendation with Mr. Smith, and we are asking the court to adopt it.
Sir, anything you want to tell me before I impose sentence?
No, sir, I just wish that, I know the decisions I've made while under the influence of alcohol haven't been some good ones. And I just wish I would have seen that at an earlier age. That's about it.
Sentence of the court, $125 statutory fee. I'll order 93 days in jail. Credit 32 served. Defendant is to serve the balance. He is to complete the in-jail Dawn Farm program. The court will consider early release upon his completion.
Thank you, Your Honor.
Court does call the case people versus Rebecca Miller.
Assistant Public Defender Natalie Pate with and on behalf of Ms. Miller, who is present via Zoom. Ma'am, can you please unmute and state your name for the record?
Rebecca Miller.
Thank you, Your Honor. I've had the opportunity to review the report as well as recommendation with Ms. Miller. The only very brief correction we have is to her mailing address. She's requesting that apartment 8 be added to that. Outside of that, we have no corrections to the report and would ask that the court adopt probation's recommendation.
Ms. Miller, anything you want to tell the court before I impose sentence?
No, Your Honor.
Sentence of the court, I'll place you on 12 months probation. You are to pay $480 fines and costs, $360 probation oversight fees. When can you pay that, ma'am?
I need a payment plan, please.
A payment plan as arranged by probation.
Thank you.
There's to be no use of alcohol, recreational marijuana, or any illegal drug. You'll be subject to random testing as requested by probation. You're to complete an outpatient treatment at Dawn Farms, including all recommended aftercare with status reports to probation. You are to attend a minimum of 3 AA meetings per week with monthly verification to probation. You are to complete 25 hours of community service as directed by probation. There's no going to any Meijer store in the state of Michigan. I'll order 93 days in jail. Credit 2, the balance is suspended. Thank you.
Thank you. Thank you, Your Honor.
Thank you, Ms. Miller.
Court
Thank you.
does call the case people versus Michael Collison.
Good afternoon, Assistant Public Defender Lauren Perry on behalf of Mr. Collinson. Mr. Collinson, please state your name for the record.
Your Honor, this is Michael Collinson.
So, Your Honor, I guess there's kind of two pieces of why we're here. There is an allegation of Mr. Collinson's tampering with the tether, I suppose, and then his discharge from treatment. And I'd like to address both.
Sure.
I hope that the court got, I mean, regarding the tamper, I think that, I've had an opportunity to speak with Mr. Collinson for a long time about both of these issues. Looking at the pictures, to me, it looks like wear and tear. Mr. Collinson was brought in with the tether still on his leg. He was in the jail for, I think, 2
The
days.
cuts in the strap are wear and tear.
One of the cuts was, I think, already there. There was like a slit in it. As he wore it a few months ago, he noticed it getting worse. So that has been there for months, and there was no allegation that I did not receive a violation report that it was cut. And I think the second one is kind of similar. It seems to be about the same length as the first cut. And from the rubber in between is kind of looking like it's weakening to me. Again, it was not removed from his leg by him. It was removed by the services group that facilitates the tethers. So he got, the cut is deep, but there's no, if he wanted to, he could have gotten it off. I think, like I said, it's been looking like that for a couple months, and there was no prior allegations that he was tampering with it. He's been wearing.
Saying it is just by happenstance that these two cuts that are almost at equal distance happened, cutting through the one part of it that you're saying that's just wear and tear.
Yes.
Okay.
Yes. I mean,
I had
again, if he wanted to get it off, he could have gotten it off. I don't understand
I had no reason to cut the tether.
if he was trying to evade tracking or anything like that, if he did do those cuts, he could have gotten it off, and he didn't. And he came to jail with it on and had it while he was in custody. He's had it since May, and there's been no other allegations of tampering with the tether or evading tracking or anything like that. Again, Mr. Collinson denies tampering with it at all.
Your Honor, I had no reason to tamper with the tether. I ran from the dentist the moment they told me they were going to discharge me. The biggest concern I have here, Your Honor, isn't going back to jail. It's losing the housing that I gained in my sobriety here. I have through the blessing of the court, I've made a lot of successful gains. I've completed 74 days in treatment. I never had a behavioral problem at Dawn Farm. The new treatment facility, there was just turbulence. This all has to do with the dental appointment. That's why I get concerned when we're talking about tampering, because I thought this was all to do with being discharged from Oakdale on the leave of absence. I have the contract. I called Oakdale for pickup at 3:30. I was supposed to return to.
How about I'll start and you can add. So turning to the issue of discharging, I think what Mr. Collinson was starting to say is he went to Oakdale. He was at Dawn Farm from May to July. He moved to Oakdale because he got housing through HUD, which he would move to that housing at the beginning of August. He has plans for DTE to turn on the utilities on August 6th. So he moved to Oakdale, I think because the program was a week less, he could complete Oakdale and then move into his housing. I haven't been able to contact anyone at Oakdale. I've made a couple contacts and they haven't gotten back to me. But the reason why we think Mr. Collison was discharged was because he went to this dentist appointment. The dentist appointment was longer than what his out time was supposed to be. And when he called, they said he was discharged because he misrepresented the time that he was going to be done. They thought he was going to be done at 3. He ended up calling them, I think, around 4:00, that he was done with his dentist appointment. The other piece is that from Mr. Collinson's understanding, is that they didn't understand or believe his representations about the seriousness of his dentistry issue. Long story short, he has a tooth that needs to be surgically removed. It's rotting out of his mouth. When he was at Don Farm, they sent him to the ER. The ER can't really do anything because it needs to go through not a normal dentist, but an oral surgeon. Because of the severity of the emergency, they referred him to the U of M clinic. The clinic skipped the normal 4-month wait and got him in for a consult earlier than normal. So that's why he was there. He has referrals from another clinic that he was going to saying that they couldn't do the service because he needed an oral surgeon, because they couldn't find an oral surgeon in his network.
All right, let's talk about that. This hearing had all the layers, tether, tampering allegations, dental emergencies, treatment discharge drama, and a defendant caught in the middle trying to hold on to the fragile progress he's made, Mr. Michael. Collins came before Judge Simpson facing potential probation violations tied to 2 big issues: suspicion of tampering with his tether and being discharged from a court-ordered treatment program. Defense counsel came in prepared, arguing that the marks on the tether weren't signs of tampering, but simply wear and tear. They presented photos, explained that the tether was still on when Mr. Collins arrived in custody, and highlighted that he'd never been accused of attempting to remove it. Their case was clear. If he wanted to remove it, he easily could have, but he didn't. The judge, taking this seriously, gave the defense space to lay it all out. Then came the treatment program discharge. According to Mr. Collins, he was discharged after a dental appointment ran longer than expected. He'd called Oakdale for a pickup at 3:30, but they thought he'd be done by 3:00 and marked him as a WO. It wasn't a behavioral issue or relapse, just a communication breakdown tied to a painful dental issue that needed surgical extraction. The defense laid it out clearly. The rotting tooth required an oral surgeon. He had medical documentation, and the early consult from UVM was fast-tracked due to the severity. And to his credit, Mr. Collins didn't shy away from the record. He told the court directly, "I have no reason to tamper with the tether," and added that his biggest concern wasn't jail, it was losing the housing he'd secured as part of his recovery. This wasn't someone trying to make excuses. This was someone who completed 74 days in treatment, had housing lined up through HU, utilities scheduled to be turned on, and just got tripped up by bad timing and a busted molar. Judge Simpson, as always, listened with care. The tone of the courtroom stayed respectful and thorough. The hearing wasn't about blame, it was about getting clarity, and Collins' attorney provided plenty of that. If there was a theme, it was this: sometimes progress is fragile, and while the court has to ensure compliance, there's also room to weigh effort, good faith, and circumstance. Mr. Collins may not have had every document lined up perfectly, but his record of treatment, housing plans, and consistent tether wear made a compelling case that this was more hiccup than evasion. In the end, this wasn't a slam dunk violation hearing or a courtroom meltdown. It was something much more real. It was a man trying to stay on track, a legal system trying to decide if he deserved a shot to keep going, and a judge trying to separate the signal from the noise. This one was about second chances, and it'll be interesting to see where the court lands. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.